judgment in the matter of Prudential Assurance Company Limited versus Commissioners for Her Majesty's Revenue and Customs.
This appeal concerns the tax treatment between 1990 and 2009 of UK companies which receive dividends from shareholdings in overseas companies. It raises a number of technical issues of tax law and also an issue in the law of unjust enrichment, which is of wider importance. At that time, a UK company which received dividends from another UK company was exempt from corporation tax on that income and received a tax credit equal to the amount of advance corporation tax, or ACT, that the distributing company had paid on the distribution. The dividend, together with the tax credit, constituted what was called franked investment income in the hands of the recipient company, which it could use to reduce its own liability to ACT on distributions to its own shareholders. In contrast, a UK company which received dividends from an overseas company was subject to corporation tax on that income. Furthermore, it did not receive a tax credit on the dividends. This situation was contrary to EU law because it discriminated against companies which invested in countries outside the UK. Prudential brought this claim against the revenue to recover corporation tax and ACT which had been levied contrary to EU law. It is common ground that Prudential is entitled to an appropriate tax credit and to repayment of any tax unlawfully charged. The current dispute concerns the amount to be awarded. The first issue which arises in the appeal is whether EU law requires the tax credit to be set by reference to the overseas tax actually paid, as the revenues submit, or by reference to the foreign nominal tax rate, that's to say, the headline rate before account is taken of exemptions and reliefs, as Prudential submits. The Supreme Court dismisses the revenues appeal on this issue. The judgments of the European Court of Justice establish that the credit for foreign dividends should be calculated by reference to the foreign nominal tax rate. There is no suggestion in the European case law that any distinction should be drawn in this respect between portfolio holdings, such as Prudential held, that's to say holdings of less than 10% of a company's shares, and non-portfolio holdings, as the revenue had argued. The second issue, and the one of wider importance, is whether Prudential is entitled to compound interest on tax which was levied in breach of EU law, on the basis that the revenue were unjustly enriched by the opportunity to use the money in question, or on the other hand, are only entitled to simple interest, such as would be paid on any unpaid debt. This might seem to be a rather technical point, but millions of pounds turn on the answer. In fact, billions of pounds turn on the answer. The Supreme Court allows the revenues appeal on this issue. In the 2007 case of Sempra Metals, where a similar question arose, a majority of the House of Lords held that a claim would lie in unjust enrichment for restitution of compound interest on money which was paid prematurely as a consequence of a mistake. A number of developments since that decision indicate that it failed to have regard to some relevant provisions of tax legislation, created problems in the law of limitation, which governs the time within which claims must be brought to court, and caused disruption in public finances. It's also inconsistent with the recent decision of this court in the case of investment trust companies, which explained the requirement for there to be a defective transfer of value by the claimant to the defendant if a claim based on unjust enrichment is to lie. The recipient's possession of money mistakenly paid to him and his consequent opportunity to use it is not a distinct transfer of value additional to the transfer constituted by the payment of the money itself. Accordingly, there is no right to interest on the basis of unjust enrichment. The Supreme Court therefore departs from the reasoning in Sempra Metals on this issue and rejects Prudential's claims to compound interest, except insofar as they were accepted by the revenue. The third issue is whether a claim lies in restitution to recover lawful ACT which was set against unlawful corporation tax. The Supreme Court allows the Revenue's appeal on this issue. Where a lawful ACT was set against unlawful corporation tax, the Revenue did not receive unlawfully levied tax as required for a claim under EU law. If an apparent charge to corporation tax was unlawful, that charge was a nullity. The lawful ACT could not have been set against a nullity, but would remain available to be utilised. Furthermore, the payment of the ACT did not entail a defective transfer of value which failed to be corrected, as required by the investment trust company's case. The next issue is whether, if ACT from a pool which includes both unlawful and lawful ACT is utilised against an unlawful charge to corporation tax, the unlawful ACT should be regarded as a prepayment of the unlawful corporation tax liability, or as partly lawful and partly unlawful pro rata. The Supreme Court allows Prudential's cross-appeal on this issue. Unlawful ACT is treated as set first against unlawful corporation tax. Since unlawful corporation tax is a nullity, that means that the unlawful ACT is recoverable, unless it's been set against a lawful charge to corporation tax. The final issue is whether, where franked investment income was carried back to an earlier quarter, it should be treated as having been applied to relieve the lawful and unlawful ACT pro rata, or only lawful ACT. The Supreme Court allows Prudential's cross-appeal on this issue. Franked investment income, which is carried back to an earlier quarter, is to be regarded as having been applied to relieve only lawful ACT. The Revenue's pro rata approach would have the effect of depriving a company of the tax credit at the foreign nominal tax rate, which is required under EU law.